Welcome to our podcast series, ERA Talks. Our guest for this episode is the Director General for Justice and Consumers at the European Commission. She has held this position since November 2021. Before she joined the European Commission, she was the Director General of International Legal Cooperation and Human Rights at the Spanish Ministry of Justice. She has a law degree from the University of Granada in Spain and also studied translation and interpretation at the same university. On the 22nd of October, the ERA team traveled to Brussels to meet with Mrs. Ana Gallego Torres. Enjoy this interview.
Mrs. Gallego, thank you for agreeing to contribute to our podcast series ERA Talks and for welcoming a team of the Academy of European Law to your office in Brussels. We feel very privileged to be here with you today.
Thank you very much. It is my pleasure to have you, and thanks also for the opportunity to speak about the DigiJust policies and to have this conversation with you today.
Okay. You've been the Director General of DG Justice since November 2021. Your DG covers a very broad range of policy areas. Could we start like this, by a short introduction of your DG, the topics you cover, the composition of the DG, and so on?
Sure. Indeed, as you say, the policy areas covered by DG Justice and Consumers could be in themselves a self-standing policy, each one of them. But we are structured around four main policy directorates that I would perhaps explain by grouping them together into two blocks. One block is more related to legislation and to the acquis, and namely that's DG Justice Directorate on justice policies, both criminal and civil, and also company law. And this is a directorate that has been in the forefront of building the European area of freedom and justice, security and justice. So the legislative activity of this directorate has been really prolific over the past years. The second one would be consumer protection, which is in itself also a self-standing policy, and it is about legislation on consumer rights and consumer protection, product safety, etc. Then the other block of policies has more to do with values, and this has known, as you know, a very also prolific development over the past more recent years. And we have the Directorate for Rule of Law, Democracy and Fundamental Rights, including data protection, that is responsible for the preparation and the follow-up of the Rule of Law report, and then the Equality and Non-Discrimination Directive. So this is, it is also very legislative, and it has legislative proposals, but it has more to do with the values and policies, strategies, and this kind of policy tools. And then, of course, just to finish, we have a cross-cutting dimension of all these policies when it comes to international matters. Let's say each one of these policies have an international dimension in itself, and also more recently, of course, the digital dimension of all these policies, because each one of them has a very strong particular digital dimension, be it fundamental rights, be it company law, consumer protection, digitalisation of justice. It's a cross-cutting dimension that spans across the DG.
Thank you. The portfolio is so broad that if you agree, we will focus on four topics, which I think, as I understand, are at the heart of your priorities. The digitalization of justice systems, you mentioned it. I would say the change, the future changes in the European criminal justice, consumer protection, very important, and the rule of law. And I would like to begin with the latter, the rule of law, which is a fundamental value of the EU treaties. And the European Commission is, so to say, the guardian of the rule of law. And you have different tools at your disposal. And one is, you mentioned it briefly, the rule of law report, which is published yearly. Could you please recall the purpose of the rule of law report and its scope, which topics it covers?
Mm-hmm. Indeed, the rule of law report started, the first edition was in 2020. So this year we have published the 6th edition of the rule of law report. And indeed, the purpose at the beginning and throughout these 6 years of evolution has been mainly preventive, has been to, first of all, gather a wealth of knowledge and evidence and expertise on the developments of rule of law related issues in the member states in order to have a good and fair understanding of how these topics evolve, not only from the perspective of the report each year, but also, as you rightly say, it is published every year. So we have a dynamic overview of how things evolve. And by gathering all this knowledge and building this expertise, we get to understand the context in the national systems of how certain topics evolve, and the purpose is mainly preventive. It's identifying the challenges, identifying also areas for improvement, and also signaling good practices and perhaps things that can serve as a good example for other member states. So in this regard, it is a very solid tool to allow for informed decision making. And for that, you need to build this knowledge and this expertise over time. And for that, of course, we have we rely on different sources. It's mainly member states' contributions through the questionnaire, but it's also interviews in the country visits with all kinds of national authorities, but also civil society organizations and other associations of the judges, prosecutors, and legal professions that and civil society that also provide an input and provide their views. And with that, we have a pretty comprehensive understanding of the situation in the member states, both for each report and also dynamically, because we have this dynamic overview. So this prevention purpose, which is primarily the goal of the rule of law report, is based on thorough knowledge of the situation.
Mm-hmm. I've read with great attention the 2025 rule of law report, and what are, from your point of view, the key findings, the main recommendations, and what shortcomings have you identified? And beyond maybe the usual suspects, which member states are of particular concern to you?
I should start perhaps by referring to the areas of attention of the rule of law report, indeed, because as it was from the beginning in the first rule of law report up until now, it is structured around 4 main pillars. The first of all, the first one is judicial independence, where we look at things such as justice systems in general, where we look at judicial independence issues, quality and efficiency of justice systems, the autonomy of the prosecution service, and developments around the functioning of justice systems in the member states and justice reforms. The second is anti-corruption framework, how the architecture put in place in member states to fight corruption can effectively provide for a good outcomes and allows for a track record of high-level corruption cases, etc. Then we look also at media freedom and how member states organize this very important element in a democracy. And finally, we look at checks and balances issues and the institutional framework in the member states. So you were asking what are the main findings?
Mm-hmm.
Well, over the years, what we've been able to gather is a very detailed analysis of many different topics and how they evolve in the member states.
Mm-hmm.
And for example, in the justice systems, what we look at is how member states and how the justice systems safeguard and guarantee judicial independence. This is key for a democracy. This is key for rule of law, a well-functioning rule of law. And we look at things such as the functioning of councils of the judiciary, judicial appointments, top judicial appointments, whether they have sufficient safeguards in place in order to allow for undue to prevent undue pressure,
Mm-hmm.
and to allow for really independent judiciaries. And in this regard, I can say that that indeed the methodology allows also for a pretty balanced overview of the situation in the member states, and we see developments in all of them. I mean, really, what's important here to say is that in all member states there are things to improve. There can be different developments that also deserve attention and deserve a close look to avoid deterioration and to avoid some backsliding in certain member states. So I would say that the main finding is that it is worth looking at each and every member state. And in general, we see that the report, and perhaps we can discuss about that a bit more. But the report is well taken by the member states, in the sense that they trigger the reports trigger reforms in all these areas, and they have a positive effect. Of course, there are concerning developments in some member states that we had to look up very closely, and it's precisely in this regard that the detail and evidence-based approach is so important, because when we look at concerning developments in member states, we need to be able to substantiate really what are these developments and why they are concerning for the functioning of the rule of law in the member states. And this is this rule of law report, as you can imagine, is not just a theoretical exercise, because it is in the center of the rule of law dialogue and the rule of law cycle, not only with member states, but primarily with the institutions, with the European Parliament and the Council, and also in the member states with national parliaments, with national authorities, and across civil society and nations as well. Exactly.
Yeah. I can imagine you are about to start with the preparation of the 2026 report, and I was wondering, because this year that was the first time that you had Serbia and Albania, and I was wondering if for next year you are planning to add Bosnia and Herzegovina, Moldova, Ukraine, and maybe what about Georgia and Turkey, which are also EU candidate countries?
Indeed, the rule of law report hasn't been static. We have published 6 rule of law reports, indeed, but each of them has introduced a new feature.
Mm-hmm.
And at the beginning, it was the recommendations. Then it was the follow-up to the recommendations, and then it was the enlargement countries. And indeed, on this year was the second time that we looked into some enlargement countries. In 2024, we included Serbia, Albania, Montenegro, and North
Montenegro, indeed, yeah.
So 4 enlargement countries that were at a level of preparation or progress that allowed to jump in the rule of law cycle. In full coherence and complementarity within enlargement reports, of course, because let's not forget that all these countries are following their own path towards accession. But the idea of integrating them already in the rule of law cycle was to put them on an equal footing with member states and start to assess also their progress and their concerns on rule of law issues, also in the context of the rule of law report. So you were asking, what about next year?
Yeah.
Well, I cannot possibly say what will happen next year, because indeed the decision to include enlargement countries in the rule of law report is based on objective criteria, based on the level of preparation or the level of progress. So what President von der Leyen said when she announced that the enlargement countries will be part of the rule of law cycle as well, was that if and when ready, as and when ready, they will be part of the of this exercise. So indeed, we look into rule of law issues as part of the enlargement process and in the enlargement reports, but as and when they will be ready to also be part of the rule of law report, we will incorporate them.
This is a political decision, so to say.
It is a political decision, but it is based on objective criteria on the findings of the situation.
So all in all, after 6 years of experience with this report, you would say that the rule of law report is efficient as a preventive tool, is efficient, sufficient to in terms of changes made in the member states over the years?
Well, again, this is a question that is difficult to say yes or no in general, because it very much depends on what areas we're looking at, what member states we're looking at. But as a general, let's say, takeaway, I would say that the exercise as such is consolidated. It is now based on an agreed methodology with member states. So all member states are in an equal footing. There is an objective and consensual methodology to gather the information, to provide input. And we test this methodology on a permanent basis with member states through a meeting of rule of law contact points, so that we permanently improve and adjust the methodology in agreement with member states in order to improve the exercise, to improve the outcome. And through and this is again very important to bear in mind, through the follow-up to the recommendations and the rule of law dialogues, the national rule of law dialogues, and the political outreach and technical outreach to member states in preparation and follow-up of the rule of law report, we engage to a great extent with national authorities, and we see in real time how the reforms are being pushed or are being stalled or are triggered. So they do. These reports do have an impact in important reforms in the member states, and there are very positive examples of that. I can mention, for example, in Slovenia, the judicial appointments have been greatly improved as a consequence. In Spain, the Council of the Judiciary could be renewed following references in the rule of law report several times. I could name Cyprus. There have been Luxembourg. There have been really important reforms that were agreed. Let's say member states agreed that this was an area for improvement. And I like to think that the rule of law report has served as a catalyst also for these reforms. And there is one, let's say, one positive consequence of the rule of law report that is, of course, very difficult to prove, because there is no there is no evidence thereof, which is the things that are prevented because of the rule of law report. So negative trends and perhaps reforms that are attempted but not taken forward because of
because they are mentioned in the report.
Exactly, because of the monitoring, not only in the rule of law report, but in the constant follow-up with the member states. And I do believe that this has had a very positive effect in some of these trends not being pursued, not being taken forward by member states, thanks to this objective and balanced analysis.
Thank you. The next topic on which I would like to hear your views is the digitalization of justice systems. This is clearly a priority of the new European Commission. And in this context, there is the so-called European e-justice strategy, which covers the time period 2024-2028. And there is the upcoming digital justice strategy from 2025, I understand, until 2030. What is the respective aims of both strategies, and how do they interact or complement each other?
Mm-hmm. Indeed, the Council, the e-justice strategy is a document adopted by Council, indeed. So it's member states that have given themselves this strategic document and this action plan for putting in paper and agreeing on the priorities on digitalization of justice. And it promotes universal access to digital justice. It also promotes exchange of best practices, exchange of examples, a repository of good practices and experiences in member states, and it is a collaborative document by member states. On the other side, the Commission's digital justice strategy at 2013, that, as you say, will be adopted later this year and will span until 2030, is completely aligned with the e-justice strategy, and it tries to translate political priorities into actions, into deliverables for the next years. So we intend to put in place the digital by default principle, and it doesn't only refer, let's say, to the digital justice, yes, but it's part of a broader strategic plan to put on the services digitally by 2030. So it is also part of the bigger and the broader objective of the Commission to have all the services of the public services online by 2030. So I would say that the objectives are the same. They share common objectives and principles. The principle of inclusivity of technologies, interoperability is absolutely key to allow for a consolidation of the digitization process. We look at real-time tools, how we can introduce tools that will facilitate the work in national administrations in general and justice in particular. Also, how to make better use of video conferencing technology, artificial intelligence, of course, and how to make best use of this technology. We look at efficiency gains for courts and the judiciaries, because technologies and namely the possibilities opened by AI are infinite, but the technology can alleviate to a great extent the workload of the courts, case allocation, online dispute resolution, and take up routine tasks as well that can liberate the judges to perform a more specialized work. So I would say, and of course, innovation. Innovation is also a common principle on both strategies.
In this context, I would like to ask you about the issue of public trust and AI in justice. From your perspective, which safeguard is most crucial to ensure that the integration of AI into Europe's courts in the years ahead strengthens public trust rather than undermining it?
Yes, absolutely. This is the key challenge for the next years, to introduce technologies, these new technologies, and namely AI, without undermining procedural safeguards and fundamental rights, and thus creating trust among the public in the use of these technologies. These technologies have a great potential. As I say, they have a great potential for growth, for stimulating investments, for a well-functioning justice system is key to attract investment, to alleviate resources also from companies and businesses in litigation, because if the justice system works better, there is more legal certainty, and litigation costs less. But of course, it comes also with risks, and the main risk in the use of AI in justice systems is that it impinges into the protection of fundamental rights and the effectiveness of procedural safeguards. And that's why the AI Act labels justice systems as high risk, of course. So fortunately, we do have now a legal framework in the AI Act to provide for these safeguards and to allow for a safe and trustworthy rollout of this technology. How can we preserve fundamental rights and procedural safeguards in the use of AI? Well, first of all, we need to address biases and automation in these routine tasks that can be taken up by AI, but there must always be ultimately a human decision behind these technologies. So it's very important that legal practitioners and the general public feel comfortable using these technologies because they are safe and because procedural safeguards and fundamental rights are not undermined.
Mm-hmm. In this context, I propose to move to a topic which is very close to ERA's heart, which is training. And according to the European Commission's report on European judicial training of 2024, it seems that we understand that less than 5% of judicial training currently addresses digitalization and AI. In your view, what is the most effective way to close this skills gap so that justice professionals can use AI tools, I would say, confidently and responsibly?
Mm-hmm. The fact that your question is so pertinent is very clear in the adoption of this digital justice strategy together as a package with the judicial training strategy. It will be adopted together because there are so many links between the digital justice strategy and the judicial training that one cannot live or be effective without the other. Indeed, we need to invest enormously in upskilling legal practitioners, judges, prosecutors, law enforcement, lawyers, all legal practitioners in the use of these technologies. And it has to have a judicial training, a central role in supporting the digital transition. And I would say that there are three elements in which the training of judges, prosecutors, and legal professions need to focus very much, which is, first of all, the digital skills. I mean, the use, the handle of the tools, the digital tools, and how, I mean, it's not that the judges need to become IT experts, but they have to be comfortable using these technologies, because more and more they will be part of the decision-making process. So there will be tasks that they will not be able to delegate entirely in their activities, because they will be so much embedded into the decision-making process. Second, they need the legal knowledge. There is a part, the digital rule book that has been adopted, but not only that, group of legislation, but also many other, and I would say that most of the new legislative proposals that are adopted now have a digital angle somehow. So they have to have also the legal knowledge and understand the tool and the law, the rule, so that they can put them together in their decision-making process. But then there is a third angle that is extremely important in the work of the legal professions when handling digital tools, which is the awareness of how these tools can effectively affect negatively fundamental rights, individual rights, how biases work, how transparency is needed, and how these, just to be aware of the risks, the potential risks of this technology would already be a very important part of the training process. So I think here, of course, institutions such as ERA or the EJTN play an important role together with member states, because let's not forget that this policy will necessarily be rolled out and implemented with member states who provide for the most part of the judicial training. So it has to be in agreement with them and in cooperation with them. And here, of course, one question that is perhaps not so easy to answer, but is the funding. There will be a great need of funding, both from member states and from EU institutions to be able to roll out this digital by default by 2030 and the use of these new technologies.
Yeah. Thank you. Next topic of this interview, European criminal justice. Since the last directive from the Stockholm roadmap came into force, it seems, if I may say so, that things have quietened down a bit, and regarding procedural rights in criminal proceedings in the EU. And if we consider the issues arising from old measures, old instruments, for example, European arrest warrants, or new measures like with the EPPO, is the Commission considering developing new tools and guarantees to ensure, which is key, a fair environment for the accused and for the defendants during criminal proceedings?
Yes, indeed, and I was mentioning this at the beginning of the interview, that this DG has played a very important role in building this criminal law acquis and building the European area of justice, freedom, security, and justice. And it has done so by putting on the table one proposal after the other, both on judicial cooperation, but on procedural safeguards as well in substantive criminal law. So now we've made substantial progress in building this area, and this has been absolutely key in building and consolidating mutual trust between judicial authorities and between member states in general. Now there is a certain degree of mutual trust that we take for granted, but it was not so obvious not so many years ago. And the acquis of on criminal law on all these areas have been absolutely key in building and allowing this trust. So it is a fair question to say, so what now? What are we going to do now? And for that, the Commission has, and DG Justice in particular, has organized a high-level forum on the future of criminal law, precisely to ask this question, because we genuinely ask the same question to ourselves, and because it is a shared competence and we don't operate in a vacuum, we need to have the buy-in and the views of the different stakeholders, and notably member states. So the idea of this high-level forum was to allow for a honest, open, and transparent exchange of views on 4 different topics in relation to European criminal law. Substantial criminal law, of course, because as you know, we have more than exhausted the list of crime categories on Article 83, and we have already used the open clause in paragraph 2 in order to come up with new harmonization proposals, but we wonder what is next in the European substantive criminal law. Also on procedural criminal law, that's after the 6 directives that were included in the roadmap, we can now also legitimately wonder what is next, whether admissibility of evidence would be an area to harmonize, detention, these very sensitive, very complex and not so straightforward topics that deserved a discussion with member states and stakeholders. The third area was digitalisation that we just mentioned. And then, fourthly, it was the role of agencies, EU agencies and bodies in the context of criminal law. So we've had really good discussions. We've had planned 4 plenaries of this high-level group, high-level forum for 2025. Of which we've done already 2 of them. So there will be, and there have been really very good and constructive discussion. Those were the objectives, and the takeaways of the discussions are that indeed there is a commitment to advance in many areas. Perhaps some more diverging views on, for example, procedural safeguards, less appetite, let's say, to engage on that. But we will be looking in the third plenary also to, for example, detention related matters that still generate this lack of mutual trust that is so important to deliver good cross-border cooperation and cross-border justice. We need to attain a level of mutual trust that allows for cross-border cooperation and transnational justice to really be effective. And of course, you mentioned on judicial cooperation, we have the European arrest warrant. That is our crown jewel, of course, and that functions mostly very good. But indeed, over the past more than 20 years now, there are, I think, more than almost 195, around 95 preliminary rulings of the European Court of Justice that somehow have shaped the framework decision in a way that is no longer on the paper. So we wonder also how to make life easier for practitioners and for judges and prosecutors to keep the pace with this very prolific case law. And more broadly, the question on Lisbonization of the old framework decisions has been discussed as well. And the Commission is preparing a study that will be published by the end of the year, and then we will take it from there. Because of course, every decision, and mostly in this, in particular in these areas, need to be substantiated and needs to be evidence based. So sometimes, normally the impressions and the intuitions are confirmed by the evidence, but we still need to see the result of this study.
Well, thank you very much. The complete and official name of DG Just is Directorate General for Justice and Consumers. You mentioned it at the beginning, so I would like to finish this interview with a few questions about consumer protection in Europe. Competitiveness is really the leitmotif, the guiding principle of the new European Commission. I still call it new European Commission. However, consumer protection is often seen, rightly or not, this is not the debate here, but as an obstacle to businesses in the EU. And my question is how consumer protection now is, let's say, embedded in the competitiveness narrative.
That's indeed a very good question, because, as you say, this is a narrative that sometimes comes up together with consumer protection or other areas of legislation, but namely on consumer protection. And indeed, competitiveness is indeed our main challenge today, and this is not at all at odds with consumer protection. On the contrary, I mean, if we think about this, consumer spending is more than half of the economic activity in the EU. So consumers, and by the way, we are all consumers, also businesses are consumers.
Yeah.
But consumers are an economic actor of the first position. So we cannot discuss competitiveness, we cannot discuss business and growth without looking at consumers as a main economic actor. And why is that? Because in every consumer decision, when consumers take decisions on spending, they need to feel safe, they need to feel that they can trust the product, and they need to have safeguards in place to against malfunctioning or against most of the rules on consumer protection are basically common sense. I mean, you cannot lie, you cannot give false information, because you need to provide information for consumers to take informed choices, and that they are able to trust the information the trader or the business provides. You cannot bully the consumer into buying on a way that would go counter to normal standards. You need to ensure the safety of the product you save. Think of a car, think of a child's toy, think of food we eat. I mean, of course, we have to have simplification and reduction of burden for companies in our mind when we legislate about consumer protection. But no one can say that consumer protection is not a must if we want to foster growth, competitiveness, and investments. Because the level of consumer protection that we have in the EU is by far one of the best in the world. So, and this is precisely one of the reasons why consumers in the EU amount for such a big share of the economic activity. Yeah. Also partly because of this protective and this protective framework.
Mm-hmm. The new EU Consumer Agenda 2025-2030 has been announced and is expected to be adopted in the last quarter of this year. So, as I understand, it will feature several initiatives such as the Single Market Action Plan, the Digital Fairness Act, the Consumer Enforcement Initiative. Could you maybe give us a sneak preview of what is expected here and maybe concrete examples for the benefit of European consumers?
Yes, it's a bit confusing that the previous consumer agenda was the new consumer agenda. Now there is no more word to say new consumer agenda, but indeed the consumer agenda for the next period will build on the achievements of the new consumer agenda that will expire by the end of the year. And indeed, it is planned for adoption by the end of the year. And the priorities for this consumer agenda are also a consequence of the achievements and the developments that in the economic world of in relation to consumer protection. First of all, we will focus very much on enforcement. Good. I was mentioning before that the consumer protection framework is key to promote and to build trust among consumers. But enforcement of these rules is equally important to make it credible, because otherwise it's a number of legislation that if you don't enforce, remain almost voluntary to comply with. And they all have a purpose, so we need to ensure that this protective framework has teeth, has really the possibility to be enforced. So we will be looking at enforcement very closely. Very well. We will look at digital fairness, because even though digital was also part of the new consumer agenda, but over the past 5 years, the development, for example, on e-commerce has been outstanding. The presence of digital tools and digital consumer goods in our daily lives is stunning. So we need to look into whether the consumer protection framework is fit for the digital products. Mm-hmm. And for that, as you probably know, we conducted this check, this fairness check, digital fairness check, in order to look at the rules, the rule book on consumer protection, and see whether it could stand. And basically, it mostly stands because it is based on principles, but we have identified a number of areas where we need additional rules, additional provisions to provide, to adapt the principles of the consumer protection framework to new realities that didn't exist before and that require particular attention. We will look also at sustainability issues. In the past mandate, we adopted the directive on empowering consumers for the green transition that precisely aims at providing information for consumers to do informed choices. Also avoids false claims of sustainability or good for the environment, etc., and tries to also promote reasonable consumption and avoid things that not only are bad for the environment but also bad for the consumers. And then finally, we will look at one cross-cutting area, which is vulnerabilities in consumers. Now, vulnerability has a different meaning or a different perception of what it is. Before, we would say that there are vulnerable consumers, but actually there are vulnerabilities in consumers, because we all can be vulnerable at one point in one particular area. Of course, age or young age or old age can be an element that creates vulnerabilities, but financial situation can also be a vulnerability. The digital gap is a major vulnerability for many people. So we have to look at vulnerabilities on a broader way, on a more cross-cutting way, looking at circumstances that create vulnerable consumers, but who are not necessarily vulnerable per se. Yep. So this will also be an important part of the consumer agenda.
Thank you very much. We have reached the end of this interview. Thank you very much for your time and for all your answer. Thank you so much.
Thank you.
Thank you.
My pleasure.